Hi everyone, welcome to this seminar on skilled worker sponsorship, the top 10 trickiest questions. My name is Joanna Hunt. I'm head of immigration at Field Fisher. I'm joined by my colleague Gillian McKerney, who is a senior associate with our firm as well. And the aim of today's session is to give you a bit of a run through of what we see are the top 10 trickiest questions within the world of skilled worker sponsorship. And the inspiration behind this session is the fact that we often see the same questions coming up again and again from some of our clients. So it's clearly there are similar areas, similar problems that businesses encounter, that they experience, and that cause confusion. So we're hopefully going to go through some of that today. That will hopefully be answer some of the questions that you have. Obviously, as with anything, one person's tricky question may be the simplest thing in the world to somebody else. So we try to tailor this session to ensure that those with kind of only a very brief knowledge of the sponsorship system can get something out of it, but also that we can drill down and go a bit deeper. So those of you with a more sophisticated knowledge will get something out of it as well. Because this is all about questions, we are hoping to rattle through the top 10 within the hour, leaving us 15 minutes at the end for you to pose any of your questions that arise from what we've been talking about, or those questions that we may not have covered that you always wanted the answer to. We're going to be monitoring the questions on our system, so please do tap them in the question box. So without further ado, we'll crack on because there is actually quite a lot to cover, and unfortunately we don't have a kind of top 10 music or countdown system, and I do have to say these aren't in any particular order of complexity either, and this is very much our choice of what we consider to be a tricky question. There isn't a kind of national empirical data behind this, but hopefully this is going to cover some of what you'll see. So the first question is about key personnel on a sponsor license. So as many of you who hopefully have a license will know, once you get a skilled worker sponsor license, you need to name certain individuals within your business to act as key personnel. So for those of you who are on this session who may not have a sponsor license already, this is going to be one of the first issues you're going to have to consider. Who can act as your key personnel? And I'm just going to take you through what these different roles are so you can understand them, and then perhaps have a think about who could take those roles on within your organisation if you are in the process of applying for a licence, or if you're aware of the fact, and this is something we do see day to day, the authorising officer moves on, a key contact moves on, who could take that role instead if they're due to move shortly. So when your licence is set up, you must name certain individuals to act as key personnel on the licence. And the three key ones are authorising officer, key contact, and level 1 or 2 users. All the key personnel, and this is very important, particularly now we're seeing within our clients as well, where HR function is being dealt with from different countries, the key personnel on the licence have to be based in, or primarily based in the UK whilst they're undertaking their role. So this means that if your HR resource is coming out, or your HR is managed out of the US, for example, unfortunately, they will not be able to take on these roles in the licence, and they'll need to persuade people within the UK business to take them on. They need to be sure that they don't have any unspent convictions, and they need to not be legally prohibited from being a company director or subject to any debt or bankruptcy orders. So there's a kind of good character requirement that attaches to it. The authorising officer is the most important person. So this is the individual who is the named person on the licence. Their name goes on the licence summary, and it's the person to whom the Home Office wants to speak if they were ever to visit you, or to call you, or to ask you questions about your sponsor licence and what you do and your activities as a licence holder. So it is something that's very important. What we tend to see is that it's usually the most senior person responsible for recruitment within a business. So we tend to see HRDs, people, partners, things like that, head of people who are taking on these roles, but it doesn't have to be that. We've seen company secretaries, senior people within marketing, but also with very, very small micro companies, it may just be some a software engineer who just happens to be the only UK employee. But if it can be that within a big business, it needs to be the most senior person involved in recruitment if possible. And they have overall responsibility for the sponsor license and the activities of all the users on it. It must be a paid employee or an office holder. So we often get asked, can somebody who is a consultant to a business act as the authorising officer? Unfortunately not. They need to be, as I say, a paid employee or office holder, such as a company secretary or the like, or a director. Key contact. So this is a role where, again, named on the license, this is the person who will get a lot of the liaison and the communication from the Home Office on a day-to-day basis. So this can be somebody within the business, but also your legal representative, such as ourselves, can take on that role as well. What I would say, it is important that whoever takes on this role is somebody who checks their email. We've certainly seen clients miss certain important bits of information because they're not checking their emails regularly. But yes, again, that needs to be somebody based within the UK. And perhaps the most busy of the key personnel is the level 1 user. We're going to talk today a lot, and for those of you who are new to sponsorship, we're going to talk a lot today about the sponsor management system, level 1 users. The sponsor management system is this online portal that is the interface between companies who hold sponsor licenses and the Home Office. And to access that portal, you need what we call, you need to be a level 1 or a level 2 user, which means you basically have a login to that system. And on that system, you therefore can carry out certain key actions, which we'll go through a bit more today, such as assigning certificates of sponsorship and reporting changes in circumstances. How it works for those of you who are going through a license application process, an employee must, if you apply for a sponsor license, an employee must be stated or must be given, their details given as part of the license application to become a level 1 user. But thereafter, you can add as many level 1 users as you want. And that is also something we get asked regularly. You can add people to it, although you don't want to go mad, because you obviously don't want every Tom, Dick and Harry being able to access the system and do whatever they like on it. But it's certainly something we recommend you add your legal representatives as, particularly so they can manage a lot of the license actions and visa applications. But you also could add outsourced HR support as well. So level 1 user, they undertake day-to-day sponsorship activities, such as assigning certificates of sponsorship and reporting changes of circumstances. We're going to talk a bit more about those. And then, as I say, once the license is granted, you can add more level 1 users. But the key points about this is that you need to be aware that if any of your key personnel leaves the business, you must, their details must be updated within 20 working days on the sponsor management system. Requests, how you do this on the sponsor management system. Now, this has changed recently, which is why we're discussing it. So now requests to replace an authorising officer, a key contact, and a level 1 user now can be approved immediately when you make them on the sponsor management system, provided that the postcode of the address for the new individual is the same as the sponsor's address or legal representative's address if adding a lawyer. But if those circumstances don't exist, then for all other requests, such as increasing certificates of sponsorship, COS allocations, the priority request system is available for a fee of £200. Okay. Question 2. Okay, so we're going to move on to question 2, which is a little bit more, is a big one. And this is something, again, we're seeing questions more and more about, and I think it's something that people just don't realise when they hold a sponsor license, is in that if you hold a license, if you're subject to a merger, a takeover, there's some change of ownership, so a controlling interest of shares are transferred in your business, that can affect or have implications for the license that you have, your sponsor license. So the important point to note is your sponsor license is not transferable. As many of you have, you will have gone through an application process to secure your sponsor license. That is linked to your business. So should the structure or ownership structure of that business change, then the Home Office is in all likelihood going to need to know about it. The key actions that the sponsor must take depends on the type of transaction that has been taken place, or the number of shares that have been transferred, or if there's a direct change in the ownership of a company. And the change would only have to relate to the direct owner of the sponsor. Transactions that are further up the hierarchy of ownership, so for instance, if you have a parent company, but there has been a change of ownership in terms of the company above that, the parent company of that, then that is unlikely to be relevant. But I would suggest any uncertainty in that, it is best to seek advice, because this is something that can be picked up by the Home Office. And I've certainly seen it happen later down the line, where the Home Office have been doing various checks on the sponsor and have realised that there's been a change of ownership. Historically, that was reported to the Home Office at the time it should have been. So if there is a transfer, so if you're within your business, 50% or more of your share ownership is transferred to a new owner, so a controlling interest is transferred, then the following may need to take place. Reports will need to occur on the current licence to notify the Home Office of the change of ownership. The new owners are likely to need to make a new licence application, and then once that licence application needs to be made within 20 working days of the sale or transfer. And reports will need to be made on the old licence and the new licence to transfer the sponsored workers across. So they don't need to go and make new visa applications themselves, but the whole new licence will need to be secured. And the important point in this, that this needs to happen even if there is no change in employer. And I've worked in cases where say a business has gone into employee ownership, so there hasn't been any change of employer for those workers within that business, but because there has been a change in the ownership structure, the Home Office is still requested that a new licence application was made. So this is an area that we think that a lot of companies aren't really aware of, and mistakes can be made, and it's certainly something where you could get a surprising letter from the Home Office later down the line requesting that you make a new licence application because you haven't done so. Takeover is a merger, so if your business is completely taken over or merged into another business, again, similar actions need to be taken. So reports will need to be made on the old licence within 20 working days of the sale. The entity receiving the sponsored workers need to apply for a new licence within 20 working days if they don't have a licence already. If they've got one already, they can just simply report and the workers should be transferred across. And then reports will need to be made on the old and the new licence to confirm that the new sponsors have taken responsibility for the sponsored workers. And then in regards to 2P, so if often workers are transferred via 2P as part of a merger acquisition, sponsored workers can transfer under 2P. If though they're transferring to a new company which doesn't have a sponsor license, that new company, the company will need to make a license application within 20 working days of the 2P transfer in order to ensure that the sponsored workers can move across. A point to be made about right to work checks. And Jill's going to go through these in a little bit more depth later on. But if you are receiving workers via 2P from another organisation, you will inherit the right to work checks that company carried on behalf of those workers. So if the company did right to work checks correctly and all those people have the correct right to work, brilliant, you're fine. But often that isn't the case, and you're often inheriting a lot of problems that can come down to bite you later down the line. So the Home Office does allow the new employer who has received the workers via 2P to carry out a new right to work check of all those workers within 60 days to ensure compliance. And that is, we're involved in providing advice on transfers and mergers and acquisitions, and it is very important that when 2P is triggered, that the employers realise that that is the case, and that new right to work checks is very much recommended. But no right to work checks is required when the transfer is within the same company. Okay, rattling through, and we're already on to question 3, and it's a big one. And this may not seem on the face of it particularly tricky, but within it, what can seem quite a simple question actually has quite a complex answer. And so now we're going to move into how does somebody, or how would you know if a worker is eligible for a skilled worker visa? Because that's often, Jill and I, the first question that we get from a client, where we get an email, you know that you want to take somebody on, you've got the details of the job, but you just want to know, are they eligible for the skilled worker visa? So we're going to drill down in a little bit more depth on that. So to obtain a skilled worker visa, an applicant needs to meet certain specific requirements. And in short, they are, they'll need a job offer, because this is not a skilled worker visa, it's not a free access to work for anybody style visa, it is an employer linked visa. So they need a job offer from an employer who has already the sponsor license, and that job is up to the relevant skill level. That skill level is now RQF level 3. Used to be RQF level 6, now 3. What does that mean? RQF level 3 is what we call school leaver level, so somebody educated to the age of 18 and above. So for the vast majority of what we've seen, white collar jobs tend to now be sufficiently skilled enough. Applicants also need to meet an English language requirement at the Common European Framework of level B1. I'll explain how they meet that, but what that does mean, and certainly for those clients that we work with who are dealing with, say, very skilled but manual jobs, ensuring that they have the necessary English language for the application can sometimes be tricky. And they'll also need to meet a salary threshold for the skilled worker route and the going rate for the role. Before we go further into that, I just wanted to cover a question which actually came up from one of you guys, which was a very good question. But it's talking about working on a contract basis. And this is all about, so you say you're a company, you want to bring your worker in from abroad, but they are going to be working on a project with one of your clients elsewhere in the UK. So they're not actually going to be coming and spending much time in your office, they're going to be on site working for that client during their time in the UK. Can they do that as a sponsored worker? Well, yes, subject to some very stringent requirements. It is absolutely vital that at all times the sponsor must be responsible for all of the duties, functions, outcomes or outputs of the job the worker is doing. That's the wording taken from the Home Office guidance, which is a bit of a word salad, but basically means you need to be in control of that worker. What it doesn't mean is that you need the employment contract to sit in the UK with the UK sponsor. It can sit elsewhere in terms of the multinational company, but the sponsor in the UK must retain responsibility for what that person is doing day to day. That sponsored worker can go and work for a third party, but only if that project, well, first of all, if it's a project or a service that is time bound. So that means that there's an end point to it. So they can't go off to work for a third party to take up a day-to-day role or fill an ongoing vacancy that they have. It must be for a specific period of time. And the idea is that they go to work for this third party and they're working independently of the other people within that business. So they use the example within the Home Office guidance about an IT contractor who just comes in, does his job, goes out. And it provided you meet those requirements, then potentially the person can work on a contract basis. I would say that this is definitely an area to seek advice on if you're wanting to do it, and to ensure that your paperwork is compliant with all of that. Okay, if we revert back now to the requirements, we started off with the job offer at RQF level 3 or above. And for those of you who are clued up in all of this, you will know about standard occupational code. So how we work out the skill level for a skilled worker visa, we have to pick the standard occupational code, which most closely links to the role we've got. And I've linked on there, and we'll share the slides. to appendix skilled occupations, where all the codes are listed, and you can do a nice Control F, search for your job title, see if you can find it. Sometimes it's obvious, sometimes it's a little trickier. I'll explain a bit or some tips about how you can best try and pick a code. As I mentioned before, all of them are RQF level 3 or above. And if you see, as I put on the slide, the codes are set out as a job title and then various little salaries. And so often you're searching for see if your job title's there. If not, there are different ways to pick the right SOC code. First of all, you'll need a job description, and we will, us as representatives and some of your representatives who are on the call today, we will take the job description and often look at the CV as well to see if we can glean what we think is the best code. Ultimately, we will come back to you with a choice of what we think is the best code, but it's the sponsor who makes the final decision, because it is you are on the hook for it, and you are essentially as well most familiar with what that job entails day to day. We can take a guess at it and to the best of our knowledge of your industries, but it needs to be the final say from you. Focus should be, and this is another one of your questions, thank you for putting that in, focus should be on the job tasks, not the job title. Don't get too hung up about title. You may find that the job title that you've got is actually not on a code which is way lower in skill level, but you know that that job entails a lot more skill than what the title is showing it to be, in which case you may be justified in picking a more sophisticated code. The greatest help is this ONS occupation coding tool, which I've linked to, where you can search for much more detail of each code, which takes you through into it and provides a number of descriptions of tasks, and that will really help you make your decision. I think most of the time this is less of a problem in terms of picking codes nowadays, because there's not much. We're very rarely now having to shoehorn code jobs into more higher skilled SOC codes, but it is important you try and get it as correct as possible. The other requirement, English language requirement, fairly self-explanatory, a bit annoying I find, I think, for some professions who don't necessarily need their workers to speak a relatively good level of English. But anyway, we're stuck with it for the time being until times the government might reconsider. But the key ways that somebody can demonstrate this: if they're national and majority English speaking country, if they have a bachelor's, master's or doctorate degree either awarded in the UK, taught in a university from a majority English speaking country, or that was taught or researched in English, and we have to go off and get an ECTIS confirmation of that. If not, we're looking at an approved English language test, and that is a thorny area. Again, it's an area that we can see applicants get tripped up. They have to pick the right test at the right centre at the right level, and believe me, it isn't as obvious as it seems. So again, do get advice on that if you need to be. They can also meet it if they have a GCSE or a UK school level qualification whilst they were awarded under the age of 18, and then some professions rely on their language that they used for their professional entry. Salary threshold. So this is the big one. If the salary, so there are various salary thresholds for the skilled worker route. If the salary is above 26,200 and the going rate for the job, the applicant will be eligible for a visa. The going rate refers to the minimum salary for the role indicated in the SOC code. But if the salary is above 20,260 or more, if the salary is not above the going rate for a job, the applicant may still be able to meet the shortfall in other ways. For instance, if they're a new entrant or have a PhD, or they're working in a shortage role. I'll explain a bit more about new entrants. If you have any questions about those, we'll try and pick up on them at the end. The salaries no longer will include cash allowances, and also from 11th of April, the salaries within the SOC codes are based on a 37.5-hour week, no longer 39, now 37.5. So there has been some changes with the SOC codes. So I would urge you to have a look at that if you're doing applications. I've put in this slide, and I think this is one to go back to after the session, because there's a lot of information in it, but this really just explains how the points are awarded for salary and the different requirements that are there. But what basically we have to do as the lawyers is we look to see which of whether the person's salary exceeds both 26,200 or the going rate for the job. If it doesn't, we then see if there is the role is either on the short occupation list, or the person has a PhD, or are they a new entrant to the labour market, which they're under the age of 26, or they've come graduating or moving from a student visa, then they may be able to take benefit of one of the lower salary thresholds. There's some flexibility there. Just to give an example, which hopefully will help. So John is a French national who's been offered a job as a management consultant with a salary of 30k. John's salary is above the skilled salary threshold of 26,200. However, it's below the going rate for the role in the SOC code, which is 32. So cannot meet the tradable points criteria under option A. But as John is 24, he can benefit from the new entry rate and score 20 points for his salary from option E, as it's higher than the 70% of the going rate for the new entrants, which would be 22,400. So the message basically is, in short, if somebody is a new entrant, for instance, at the junior end of their career, they may be able to take benefit from a lower salary threshold. So the best thing to do is just to flag that with us as your representatives or the people you're working with, and they can calculate that for you. Okay, I'm going to rattle through to question 4. We're going at quite the rate. So what is a certificate of sponsorship? So some of you might be sitting there going, oh gosh, what is a cause? What are we talking about here? So a certificate of sponsorship is, I always talk about it as the virtual work permit, and this contains the details of the applicant's job, including salaries and SOC codes and all that information we've been talking about, eligibility. We plonk that in the COS, and then we access them, we draft them on the sponsor management system. So we have the license, we get access via our level 1 login, and we can draft the COS. The important thing is that we need the certificate of sponsorship in order to get a reference number beginning with C, which the applicant then used to make their application. A fee of £199 is paid for a certificate of sponsorship, and also the immigration skills charge, this levy that's placed on employers. This must be paid by the employer and should not be subject to a clawback. I would say one of the big questions we get more and more now is, can we put a clawback in a contract? What costs can we recoup? And Jill is going to talk a little bit more about that. But there are 2 types of causes, undefined and defined. I'll take you through. Undefined, those are for certificates of sponsorship that you are given as part of as a license holder every year. And this is certainly one of the questions we get, is that every year a lot of you will have been getting emails telling you to log on to make your annual request of allocation for your certificates of sponsorship. They are only to be used for applications that somebody is making within the UK. So if you're thinking about how many to request, you just need to think about, are we going to extend anybody? Are we going to recruit anybody from within the UK? Will anybody switch into the skilled worker category already here in the UK? It doesn't include people who you're going to recruit from outside. What's happening though is from June this year, those emails are going to stop. So you might be relieved to hear that. You'll no longer get these emails asking you to make your annual allocation increase. It's going to be all automated, and the amount you'll be given will be based on your previous year's usage. So that's fine if you're using a lot and you're going to stay very stable. What it won't be good for is those companies are anticipating an uptick in their recruitment. If so, you can always request increase throughout the year, but it costs, those requests can sometimes take 18 weeks, and it costs £2,200 to expedite. And right now it's getting quite tricky to get them. So pre-planning on that is worthwhile. But yeah, just a flag, you no longer will be bothered by these emails in the future. The defined certificate, so this is for anybody who applies from outside of the UK, and they take about a working day to approve, and we apply for them as and when we need them. There's no allocation, so you don't need to count those in, you don't need to factor those in with the allocation, because we just get them as and when we need them, and we log on and request them on the certificate of sponsorship. Okay, I'm getting to my last question from me, and I'm only just about coming up to my time. So question 5 was about applicants getting the different forms of status that you may be seeing. So we get, You may have noticed that some skilled worker visa holders are now getting e-visas and some are getting biometric residence permits. Why is that? Well, I'm going to tell you. So there are now two ways that an applicant can apply for their visa, or certain applicants can apply for their visa. There is what we kind of call the standard application process, which I'll talk a bit more what that involves. And that, if somebody goes through that, they will get a biometric residence permit if they're in the UK, with a little plastic card, or an entry clearance vignette if they're outside, a sticker, and then when they come in, they pick up their biometric residence permit. If they apply via the new IDB app, they will get what we call an e-visa or electronic visa status. So they're not getting a physical card anymore. The standard application process follows a familiar theme. Applicants, it applies to the people who have to use the standard application process will get BERPs, will be those non-EU workers applying from outside of the UK and non-EU workers who do not hold a biometric residence permit who are applying from within the UK, or those who just simply don't want to or can't use the app, and we do encounter those people. In which case, those people will have to use an online form and they have to attend a visa application centre either in the UK or abroad, depending where they're applying from, and their documents are uploaded and scanned. Once the visa is granted, they're given a 90-day entry clearance vignette, and then they pick up the biometric residence permits in the UK. And for those UK-based employees, they will be sent a biometric residence permit. So they'll still have those plastic cards. But what you will notice, and this is one of the most common questions, and I can't wait till next year when we're going to get this significantly in the run-up to it. By the end, you will notice that a lot of these cards all expire on 31st December 2024. And we have a lot of emails, panicked emails from applicants who've seen that their visa is valid to some date in 2026, and they email us going, how come my BRP says 2024? This must be a mistake. It is not a mistake. The government is basically making these little plastic cards obsolete from the end of next year. So nobody will have them. They will all be phased out. And everybody from that point will have electronic status. Well, this is likely to be another one of those Home Office initiatives that's going to bring up a whole host of problems. And so we're waiting for further guidance next year about what that means for right to work checks, what that means for you as employers. And we'll obviously be doing training and information on that when we have more. But just to be aware that 31st of 12th, 2024 is not a deadline on their status. It's just when the card becomes obsolete. What you need to make sure, though, if you're doing right to work checks, is that you're diarising as the expiry the date in the approval email. That's the full grant of status, not the date on the permit. Great. Okay, just so applying via the app. So this has been around, gosh, for about over a year now. It works pretty well, the app. So it's an app. What this does, the app enables people to avoid having to go to the visa application centre. They do their ID checks via scanning their document and holding the phone up. And yeah, it works really well for those who can use it, who are. It's available to EU workers, both in and out of the UK, and those non-EU workers within the UK who have a biometric residence permit unless they're under 18. So they verify their ID via the app, they do complete an online form, and then the minimal documents are required, and they don't need to attend a visa application centre. What you just need to be aware of as employers is that you need to check their status via the View and Prove portal using the share codes, which Jill's going to take you through. I'll just do a reminder here, but we will go through these in a moment. In terms of right to work checks, these different forms of status have different ways of checking. A 90-day entry clearance vignette. So if someone presents for you with a sticker and a passport, that must be checked via a manual check. So you must physically check it. That's the only way of doing it. If you're presented with that, you'll need to check in before that 90 days expires to ensure that that person then has their biometric residence permit. The biometric residence permit must be checked via an online right to work check, and the e-visa can only also be checked via an online right to work check as well. Okay, I think I'm going to pass to Jill now, who's going to do a range of the questions. Please, as I say, we're going to scoop up questions at the end. So anything that I've covered that you want more clarity on, pop it down in the questions and I will monitor those. But I'll pass you over to Jill.
Great, thanks very much, Joanna. Right, so I'm going to start with question 6. What do we do if there's a change in the start date for a sponsored worker? So when we're trying to decide on a start date for the application, there's a lot of things that we need to take into consideration. The sponsor, for example, may have an urgent business need for the person to start. The worker might need some time to relocate themselves or their family. Then, depending on the country the person is applying in, there might be a different standard processing time or different priority options available in that country. And then there's going to be a Home Office restriction on when the person can start. So on the COS, the certificate of sponsorship, we have to put down work start and end dates. That's effectively the period of visa that we're asking them to grant. Then on the application form, you have to state what date the person is intending to travel to the UK. So I'll explain a bit more about the significance of those things. So it's very common that we've submitted the application, and for some reason we need to move the work start date on the COS. So is that possible? Well, the first question that we need to ask ourselves is, has the Home Office decided the application? If the answer is no, then at any point up until the Home Office has decided the application, the Level 1 user can add what's called a sponsor note to the COS on the SMS to change the work starts and end dates. And then the caseworker, when they decide the application, the new dates will pop up and they'll approve it in line with those. So that's quite straightforward. If the Home Office has already decided the application, we need to calculate, is the new start date within 28 calendar days of a number of dates, including the original COS start date, the valid date on the visa, the date of grants, or the date that the person was notified of their grant. So if we calculate that and we decide that they are actually starting within the 28 calendar days, you don't need to report that on the system. They can just start on the revised date. If the worker is starting more than 28 days after those dates, so they're starting more than 28 days late, then the Home Office does expect you to report that on the system, and they do say that you will need a valid reason for having that delay. So they've given a list of what they consider to be valid reasons, but it's not an exhaustive list. And their reasons includes travel disruption due to natural disaster or pandemic, working out a contractual notice period, illness, bereavement, compelling circumstances. So if the Home Office look at it and they think it's not sufficiently valid, they may cancel the visa. So our advice is that the best practice is if it's the reason for the delay is within the person's control, if they can feasibly figure out a way to start within the 28 days, they should do so to avoid any uncertainty. If it's genuinely outside their control, then it might be something that's accepted by the Home Office. If the worker wants to start earlier than the date on the COS, that's fine. You don't need to report that on the COS, and they can go ahead with that. So you might want to consider whether at the outset you put maybe a slightly later start date, because it's much easier to bring it forward than it is to put it back. And then the significance of the travel date on the application form is that the visa will be granted from that date. So the person won't be able to travel any earlier than that date. If the person is being granted a physical visa rather than a digital visa, their physical visa will now be valid for 90 days normally, and they will need to travel to the UK in that time, or they'll need to apply for a new visa sticker. Question 7, so what checks do you need to carry out for sponsored workers before they start work? So I'm sure that you can imagine that this is about the right to work checks, which Joanna's mentioned already, and I'm going to go through these in a bit more detail. And this is really a key area for sponsors in particular. So it is a criminal offence if you know or you have reasonable cause to believe that you were employing an illegal worker, and you can face a fine of up to 5 years in jail or an unlimited you can face up to 5 years in jail or an unlimited fine. So the Home Office has said that the criminal offence is reserved for the most serious of cases. So, however, it's clearly something that you want to avoid, give a wide berth. So the employer can receive a civil penalty if you unknowingly employ an illegal worker and have not carried out right-to-work checks correctly. And you can get a civil penalty of up to £20,000 for each illegal worker. So it's very substantial. However, if you do carry out the right-to-work checks correctly, that will give the employer a statutory excuse against a liability for penalty. If you have an employee found to be employing a legal worker, there are some other penalties that include the closure of the business premises, and the sponsor can lose their license. So for sponsor license holders, you stand not only to get a civil penalty, but also for your license to be impacted. And it is more likely that you will be audited by the Home Office. As a sponsor license holder, you can be audited at any point by the Home Office, and then they will want to see the records of your right to work checks. So Joanna's referred to these already in some detail, but I'm going to go through the main ways that you can check the right to work in the UK. You can carry out a manual check, which is where you have the person's physical document in your possession. And you need to then verify their appearance matches the document with a video call or an in-person meeting. Then there is the online right to work check. So that's mandatory now if the person has a biometric residence permit, an e-visa or status under the EU settlement scheme, and you'll be able to, they'll give you a code which you can use to see their online status, and you'll need to again verify their appearance against that result. And then we have the IDBT checks via an IDSP or identity service provider, and that is where you can outsource you don't need to get the original document, because you can get the IDSP to verify that original document for you. And again, even when using this method, you still need to verify the person's appearance and results of the IDSP check against the person's appearance, with ideally a meeting or a video call. And that last one is only for British and Irish nationals presenting with a valid passport. So we thought about some of the common issues that come up that we find that employers can fall down on, and came up with some top tips for the right to work checks. So the employer has to carry out the checks themselves. They can't outsource it, other than what I just mentioned about the IDSPs. The checks have to be carried out on all employees, so not just those on temporary visas, but including all British and Irish national employees. The employer has to verify that the worker's appearance, as I've explained, is consistent with the photograph and date of birth in their document, the video call or an in-person meeting. And the check must be carried out before someone starts work. Finally, you have to retain evidence. You can prove that you've actually carried out the checks, so you need to keep clear copies of the checks and a record of the date on which the checks were taken. And so we recommend that you have processes in place so that you don't overlook the checks, that they're carried out consistently, and that you do provide training for staff carrying out the checks if necessary. You should also, as Joanna's alluded to, keep a record of the visa expiry dates for all workers on temporary visas. And you need to then carry out repeat checks before those expiry dates. So for sponsored workers only, you need to check the date that they entered the UK if they were granted a visa to enter the UK. And they need to have entered after the valid from date on the visa. So you need to check their entry stamp, if they were given a stamp, or their travel ticket or boarding pass. So I mean, what we really feel is that it is very difficult for employers to keep on top of the right to work checks. The guidance is very convoluted, and it's constantly changing. And it's very common that even the most compliant of companies will fall down on what some aspects of the check. And we'll often get the question, what do we do if we haven't carried out the check or it's incomplete in some way? And I mean, the first thing to be mindful of is that a civil penalty is only issued if a person is found to be working illegally in the UK, not just because you haven't carried out the check. But once you've passed the stage when you can do the check, then sort of past the stage when it's sort of, say, if you don't do a check before the start of work, you lose the statutory defence. You can't get that statutory defence back against a civil penalty. But what you need to do at this stage is satisfy yourself that there are no illegal workers in your organisation. So we advise that if you've not completed a check on the individual, you should carry one out as soon as possible. And then put in place processes and give training so that routinely in future the checks will be made. If you think there's an instance of possible illegal working, then you should just take employment and immigration advice, because those situations can be quite complex. And if you did complete a partial check, but maybe there's something missed, maybe you didn't have a video call or you didn't keep a record of the dates, we try and take a sort of a practical approach on what do you need to do to satisfy yourself that the person's not working legally, and then also ensure that you put in processes so that you're carrying out the checks fully going forward. So I am rattling through these. So what? Yeah. So what do we need to do if a sponsored worker leaves the business? So that's a really important question.
One we're seeing more of, isn't it, really?
Exactly, yeah, especially in certain sectors. Yeah. Sadly, we're seeing an uptick in having to have redundancy rounds, etc., which is very sad. But so what the questions that we get asked are really, what do you need to do? And well, essentially you need to report if someone leaves. But I thought it was really helpful, firstly, to kind of distinguish between a personal visa and a sponsored visa. So a personal visa is something that is being granted on the basis of the individual's personal circumstances that might include, for example, a partner visa or a global talent, so if someone's a leader in their field, for example, and so I've listed some other categories. But a sponsored visa would typically be a skilled worker or global business mobility. And with a sponsored visa, sponsored worker, their visa is tied to their sponsoring organisation. So if a sponsored worker's employment is terminated before the end date, the visa end date that is, which may include due to redundancy or voluntary resignation, the sponsor needs to notify of that termination date within 10 working days of the termination. And they need to normally provide the individual's last known contact details. So that at that point, that's the end of the sponsor's sponsor duties, but they do need to retain access to the sponsorship personnel records for 1 year from the termination date. So what are the implications for the sponsored workers? So unfortunately, sponsored workers are often quite unaware of what the immigration restrictions are on their visas. And once their their employment is terminated, then their right to work ends. So they can't work until a new visa is granted. They could work remotely outside the UK, but that absence might have an impact on their eligibility for indefinite leave to remain or settlement. And when you've made that report, the Home Office will process that or may process that. And if they look at it, they may issue a letter to the individual to give them 60 days notice to either apply for a new visa or leave the UK. So what we've found in practice is that since the pandemic, very few, almost no letters of this kind have actually been issued. But it is still entirely possible that the Home Office could issue the letter either straight away once they get the report, or they might take weeks or months, or it might not be ever issued. So the cautious side of things would be for the individual to try and submit a new visa application within 60 days from the day of the report. but they may be reassured that actually they may well have longer up until their visa expiry date to sort things out. And what we have found in the past is that the Home Office send the letter to the individual's wrong address and old address. So the individual, and even though the letter starts the clock ticking, the individual hasn't received their letter. So the individual should update their address, contact details online to make sure that it gets sent to the correct address. So we've looked at what are the options for some sponsored workers, because I know a number of employers in this situation want to provide some support and guidance to their workers. And so if a sponsored worker has a dependent, that dependent can actually continue to work on the dependent visa until the visa expiry date or until the end of the 60-day period. And then a really important point to note is that for the sponsored worker themselves, they may be refused re-entry if they travel outside the UK. So the border official may decide there's been a change in their circumstances. They're no longer working for the sponsored worker, the sponsoring entity, so they can't come back in on their sponsored visa. That would be quite a harsh view, but it could potentially happen. So if somebody is traveling, I mean, if they're coming back in, they really need to be saying that I'm just coming back in to make a new visa application. And they need to ensure that when they come back in, if they do travel, is that they must not be readmitted as a visitor, either inadvertently by coming through the e-gates or in any other way. So, and that if the person is struggling to get an alternative sponsor, there are some alternatives to sponsorship. The person, if they're married or in a long-term relationship with a settled person, somebody who has settlement in the UK, they might be able to get a visa that way. If they have a dependent, that dependent, they might be able to switch so that the dependent becomes a sponsored worker and gets sponsorship in their own right, and the sponsored worker becomes a dependent. If they're a leader in their field, for example, in tech, they might be eligible for global talent. High potential is if you've graduated from a top 50 university worldwide, and then there's a student visa which allows limited work. And from the employer's side, you can provide some support by offering to pay for an immigration consultation so they understand their options. If you're looking at sort of work notice periods, if you offer them pay in lieu of notice, that's going to bring forward their termination date, so they might not want that. However, if you offer for them to work their notice period or put them on garden leave, then that will delay their termination date and the notification date to the Home Office. So that might help them out. If you're offering an enhanced redundancy severance, they may want to exchange that for salary and extend their employment to delay the termination date, but that can have some tax implications. So beware. As I think if there's any sponsors, there'll be many sponsors on this call who are entirely aware that sponsorship fees can be very high, and they're mostly borne by the employer. So we, as Joanna mentioned earlier, clawback clauses are becoming more common, and we're getting quite a lot of questions about them. So I've covered them here in a few points to note. The clawback clause is the requirement for a sponsored employee to agree to repay fees if the employment terminates early. Yes, so thanks. Yeah. For it to be effective, it has to be signed by the employee, and it has to give the authority to the employer to make a deduction from the final salary payment. Thanks, John. And so there's some question over whether a clawback clause is enforceable in a court of law. That's untested. And but we know that the clawback clauses should be proportionate. So the obligation should extinguish after a period of time, and the amount of fees to be repaid should ideally decrease over time. And as Joanna has already mentioned, you can't pass the immigration skills charge ever onto the employee. And we think it's probably best practice to exclude the certificate of sponsorship fee as well. It may be considered unreasonable to include professional fees which are incurred as a commercial agreement between the employer and its advisors. So in the clause, you need to exclude certain reasons for termination, like redundancy, for example. There may be some risk of indirect race discrimination. And so you need to be prepared to explain why the repayment clause is necessary and proportionate, and avoid lengthy repayment provisions, and use any repayment provisions consistently with all sponsored workers. I think you may be aware that if somebody does end their employment early, the immigration skills charge may be refunded in part, depending on much longer there is to go on the visa. And if for any reason the person wasn't able to start work at all, it will be refunded in full. That's the immigration skills charge. So moving on to question 9, we've just got 2 questions to go and we can go through some questions. Great. Okay, so if a sponsored worker wants to work remotely or on a hybrid pattern, is that possible? So we've referred already to a number of reporting and record keeping requirements earlier. The government considers that sponsorship is a privilege and that sponsors should play their part in ensuring the immigration system is not abused. So they on sponsors, there are a number of sponsorship reporting duties. So they require that you report certain changes in circumstances affecting sponsored workers or the business within set timeframes. So any circumstances relating to the worker, you need to report within 10 working days. If it relates to the business, you need to report that within 20 working days. And those reports are carried out by the level 1 user. So the big one is remote or hybrid working. It's obviously ubiquitous, and so the guidance is that you have to report if there's been a change of work location for a sponsored worker. So this includes if they're working at another site or branch. So bear in mind, on the original clause, you would have put a work address. So if that person then moves to a different address than is on the clause, you have to report of that within 10 working days. If the person moves to a complete remote working arrangement, you will need to provide a business reason why the person needs to be present in the UK if they're not ever going into the office. So it might be, they need to liaise with customers in the same time zone, for example. There are various reasons why that might be the case. So the big change is from the end of March, the guidance was updated to state that if a worker follows a hybrid working pattern, which is where the worker will work remotely on a regular and planned basis from their home or other address not on the licence, in addition to regularly attending an office site, then it is a requirement going forward. So that means that for certificates of sponsorship that are issued after that date, then you need to notify if the person is moving to a hybrid working pattern. So in practice, and I think pretty much my understanding is this is going to apply almost to everyone, I would have thought, these days, or to many people, is that at the outset, when we're preparing the visa application, we're going to have to put a note on the clause to start with that the person is in a hybrid working arrangement, if that is happening from the outset. If it's not happening from the outset, then, and it changes to a hybrid working pattern, we'll need to report that change. And so other reports that need to be made. So we've already just talked about late start dates. You would also need to report if someone's absent for more than 10 consecutive working days without permission. I think we've also talked about end dates. I think there was a question about whether you need to report the end date even if the person does end at the original end date on the clause. No, you don't need to report that, only if the employment ends early. So thank you for that question. And if you stop sponsoring for another reason, that needs to be notified. If there's any significant changes in the job, so changes in the job title or core duties, or a reduction in salary. So increases in salary don't need to be reported. If there's a change of ownership, change in the size of the company. And in a lot of those reports, you're going to need to include the latest contact details for the individual. So in relation to the company, there are some aspects that you need to report, and that includes change in key personnel. Joanna was talking about earlier, change of company name, sale of the business, ceasing trading, substantially changing the nature of the business, any information that suggests somebody is involved in terrorism, criminal activity. So some top tips on reporting duties. Always report no matter how late. So if you realise that you were meant to report something a month or a year or 2 years ago, still make a report. And then at that stage, make a review and implement future timely reporting, and provide staff with training if required. What commonly happens is that the person who is the level 1 user or authorising officer, key contact, or all of those, leaves the business sometimes unexpectedly and doesn't make a replacement before they leave. It's often not top priority on their list to replace someone on the licence before they leave. So we recommend to avoid that because it can cause delays, and if you need to urgently sponsor someone new, or you need to make a report on the system and you don't have access because the sole level 1 user has left, we recommend that you always have at least 2 level 1 users. And you could also, in addition, appoint a legal representative as a level 1 user to ensure that at least one person is always going to have access. And then put in place a process checklist so that if someone is the authorising officer is leaving, they ensure that they appoint a replacement before they leave. Currently, the sponsor licence has an expiry date on it. So at least 2 people should have that in their diary, that sponsor licence expiry date, because it needs to be renewed. So final question before we go on to your questions. What records do you need to maintain to make sure the role is genuine? Part of the sponsor duties is keeping records. We've gone through a number of these right to work checks, also staff absences, pay slips, employment contract. But I'm going to talk a bit more about the recruitment evidence. So as of December 2020, there's no longer a need for skilled workers to advertise to the local workforce, but you would still may need to demonstrate that you are offering a genuine vacancy. So there's no requirement to have advertised at all, but if you have advertised, the Home Office asks that you keep some evidence of that, and it's quite flexible what you need to keep. So it can include sort of a record of the text of the advert, information about where it is advertised, record of how many people applied and how many shortlisted, and another type of evidence like the reason why people rejected and other candidates, so the candidate was selected and others rejected. So there's no need to retain applications, CVs or anything for unsuccessful candidates. If you didn't advertise, then you need to just be able to explain how you identified that the worker was suitable. So that might be evidence of a university milk round. You might be able to just simply explain that they were already working for you on a different visa, or if they made a speculative application, you ideally be able to provide some information about how you identified through an interview process that they were eligible. So yeah, just very finally, if you fail to fulfil your sponsor duties, I mean, ultimately you could lose your license. So it can have a very serious outcome. You could be prevented from sponsoring workers and prevented from applying for another license for 12 months. So it's at least worth taking the time to avoid any kind of emergency situation of this kind where any of these events occur. So yes, so thank you for listening to that. And so we have some time now for your questions, if there's any in the chat.
There are.
Yeah, so great. Okay.
Right, there we go. Okay, we are going to now, there are quite a few questions, which is great,
excellent.
thank you. Okay, I will rattle through them. What will happen if a British national hasn't got any passport or the passport has expired? Okay, so I think that's pertaining to right to work checks. So what if they have? What if a British national hasn't got a passport or the passport has expired?
So there's a list, and there's a right to work check guidance which sets out a list of documents that are acceptable, and that can include birth certificate. I don't have all the possible documents at my fingertips, but
The
yeah.
birth certificate and NI evidence, so
Right.
it can include
Yeah.
that. But yes, but I think with the expired passport is it has to be a manual check, doesn't it? Yeah.
Yeah.
You can't use the IDSPs. The next question we have, so this is quite a long one. We'll have a go. We had an individual that applied for a change in situation, switching from a government authorised exchange to a skilled worker visa within the UK, but the application took weeks and weeks to process, and it is our understanding that they cannot leave the UK while the visa is being processed. Is this correct? Yes, unfortunately. When you submit an application from within the UK, if you travel outside of the UK, the application will be treated as withdrawn. So yes, if you have delays, it does leave people stuck. Are there any exemption situations where you can travel without invalidating your visa application? I haven't seen any.
Yeah.
I don't think so.
No, I don't think so.
I mean, the best, but in those situations, to be honest, it's the best using contacts at the Home Office, which we are kind of blessed to have a few, and to just put forward urgent information. The Home Office tends to be quite good about this now, provided you can kind of pull the right lever. So yeah, Catherine, I mean, do let us know if there's anything we can help with there. Serena, sorry, you may have already asked, I've gone over this, I may have missed it, but what if we add a new subsidiary to the organisation? I didn't totally do this, but it's if you're adding a new subsidiary to your license, so you acquired another company or something like that, and you want the license to cover that entity within the UK, you need to add it as a branch to the license. So you need to make a report to the Home Office to do that. You also may want to consider if it's an entity outside of the UK and you have, for instance, a global business mobility license, that can also be added. But yes, if you want people within that business to benefit from the license, you need to report it. It's not automatic. My colleague has IDLR, definitely Tremaine. In her expired passport, which she carries with her current passport, does she need to apply for BRP? Do you want to take that one?
So her expired passport, which carries
ILR
yes,
expired passport.
Yes, so you do need, so to carry out a correct right to work check, it may be that you've already carried out a right to work check, in which case you don't need to repeat it for ILR. So it's only if she was to start a new job, really, that she would need to get a BRP in order to prove the right to work for a new employer.
I mean, yeah, it's not required, but it might be something that if she's not encountering any problems travelling, then no, she doesn't need to. But if she gets a new job, she will. Okay. I'm looking for some guidance on visa extension from one of my administrators. She's currently has a graduate visa, I think that must be, until, from what I understand, her title of administrator does not qualify for a skilled worker visa. What do I need to do, retain her employee? How can I support a visa application? So yeah, that comes down to skill. So administrator, it's about choice of SOC code. You would have to look to see what the administrator SOC code is. And I can imagine a vague job title like administrator, it may well not be considered skilled enough. I mean, the SOC code for it may be below RQF level 3. However, if you as an employer know that that job is definitely above RQF level 3, and then you wouldn't give that job to a 16-year-old, for instance, or somebody who hadn't gone through the full levels of qualification up to the age of 18, then justifiably you may be able to use another code. What it would require some kind of deep dive into the different codes to find one, and you would have to be fairly happy with the choice and on solid ground. Often we find, we've advised employers to maybe look again at the job title. Maybe the job title isn't the best descriptor of what that person is doing. But yeah, it isn't automatically a no if the SOC code for that job title is low, but you know that job to be much more sophisticated than what that code is entailing. And that's why I would use the ONS SOC code tool to go a bit deeper. And also in the first, particularly look at the job. I think the key point as well is the salary. If you're paying well above those salary thresholds as well, it's likely that isn't the right code as well, and you should be looking at a different code. Okay, I understand that you do not pay ISC on student visas transferring to the skilled worker visa. We did not realise we encouraged a few staff to transfer to a graduate visa before the company sponsors them. We understand we will now incur the ISC as a result. Any way around this?
I don't think
so. Unfortunately, yeah. No, I suppose unfortunately, no, they're on the new path.
Yeah, I think to get the ISC, you need to currently be on a student visa, is my understanding.
Yeah. I mean, unless they're one of the SOC codes that are exempt from the ISC, there's a few kind of PhD level roles which are exempt from the ISC. Yeah, unfortunately not. I mean, not for something we have time to go into now. If you want to avoid the ISC and your company is a scale-up business, there is a whole new visa category called the scale-up visa, which is a sponsorship visa which enables a company to avoid the immigration skills charge. Happy to talk a bit more about that in more depth if anybody wants more information about it, but no, unfortunately not there. How do we do a criminal records check for a foreign national? Is it done in their home country?
Yes. So there is some Home Office guidance about which provider the individual needs to go to in their country, their home country. So normally criminal record checks need to be carried out in any country in which the person has lived for at least 12 months in the 10 years prior.
But only for certain SOC codes.
For only for certain SOC codes. So when it is a requirement. Then they need to complete the checks in any of those countries that they've lived in. So they don't need to be physically present in that country necessarily, but they do need, there's a guidance which sets out the right authorities that they need to approach to get the check done.
It's very helpful now. The form prompts you when you put in the SOC code, it will tell you at the end whether you need a criminal records check. So don't worry if you think, oh gosh, doing my applicants. It tends to be those kind of healthcare, education, those dealing with people that need criminal records checks. Somebody's just asking if it will be recorded. It is being recorded, this session, so don't worry, you will be able to refer back to it. We realise as well, it's school strikes today. I'm sure a lot of people may have been wanting to listen who haven't been able to. So yes, it is recorded and we'll share the slides. And we have access to the pack at the end of the call. Yes, certainly we'll share the slides as well. Thank you, Kieran. Do you need to have already identified? Greg is asking, do you need to have already identified a candidate you wish to hire prior to requesting additional available costs on the license? Not necessarily. But what I would say is the Home Office can be a bit tricky about requests to increase COS allocations. If you say we need 3 because we are anticipating growth over the next 12 months, you might, and just provide a bit of detail, you might get it granted, but I have certainly seen the Home Office come back and say, okay, tell us which jobs you're recruiting for, tell us the SOC codes, tell us the applicants you've got in mind, and they want deeper detail. If you're not able to provide it, then they will refuse, they won't grant those certificates. So what I would say, you can certainly give it a go, put as much information as you can about why you need those candidates, try and identify the roles, at least putting the SOC code saying, hey, we know we want to say use tech roles, and we know for our knowledge of the market that we won't be able to get that from the local resident workforce. But just prepare yourself that the Home Office could come back and ask for further information, and you may have to try and bolster that request. These are great questions, by the way. Thank you, everybody. Do you want to take Serena's? Do we still need to hold current BRPs on files even though we don't now require it for right to work?
So if you have carried out the check at the beginning of the person, before the person starts work, then you need to keep that record on file until for at least 1 year after the person leaves. If you need to carry out a repeat check, you'll need to do the online check. So, and you need to have done the online check on the BRP for that person if they started after 6th of April 2022. So you would, if you did have to originally check the physical BRP, you still need to keep that on file to continue to prove that you carried out the check at the correct time.
Right, Laura's asking a very tricky question. Can you decline a candidate due to request for sponsorship due to budgets don't allow? Okay. Right, so this is a bit of a difficult one, and it does kind of wander into the area of employment law as well. From an immigration perspective, there is no obligation to sponsor anybody. The Home Office certainly doesn't put an obligation to sponsor, but what you always have to bear in mind when refusing somebody is that you are not you're not taking that decision in a discriminatory fashion. So in terms of having, a lot of companies will have policies on what they will and will not sponsor, and we would certainly suggest that's something that having the input of an employment lawyer on is well worth it. I mean, normally the principles is that what you operate with policy ensure that it is fair and that it is applied across the board consistently. So you don't make carve-outs for instance, as we see often for senior staff that you will sponsor, but you won't for some others. But yeah, there isn't a hard and fast rule on that, unfortunately, but it's about ensuring that your policy is robust and fair. Jade, yes, we definitely will give you the copy of the slides. Are acquisitions considered for 2P? Well, we covered that. I don't know, Jay, if you want to, maybe that's something I could, but we covered that earlier on. But if you have a more specific question, you can pop it in an email to us afterwards, because I know we're kind of coming up to the end, but happy to answer that at a later stage. And then I think we've got last question, Federico. A question about making an update on the SMS system. If a sponsored employee obtains ILR, is the employee required to do an SMS update, or does the skilled worker visa deactivate the moment ILR is granted? Would you like to say that?
Yes, so thanks, Joanna. So yes, you do have to notify if the ILR was obtained before the expiry of the certificate of sponsorship, then you do have to notify. If it was, you do have to notify that the person has switched onto the ILR route.
Okay. All right, we'll leave it there. Thank you. We were going to finish at 5:15, and miraculously we're bang on time. As we said, we will share the slides, we will share the recording, so feel free to distribute within your organisations. We hope we've covered some of your tricky questions today. If we haven't, you have our email addresses on the slides as well, and we're more than happy to answer those. But yes, thank you for joining on this rainy, cold day, and we hope to see you on another one of our sessions soon. Thank you.
Thank you.